Can everybody hear me clearly? All good? Everybody comfortable? Okay, today I'm here to talk about the top 10 HR mistakes and what you can do, more importantly, what you can do to actually avoid them. How do I know what these top 10 things are? How do we know that these are real? I'm from a company called Workforce Guardian. For the last 10 years, Workforce Guardian has been helping Australian employers and key advisors to achieve HR best practice and compliance. Before Workforce Guardian came along, HR and compliance was incredibly expensive in Australia. As you just heard the previous speaker talk about the costs of accessing technology, accessing people and experts. Before Workforce Guardian, you had to hire your own employment lawyer, you need to hire your own HR manager, you needed to spend a lot of time developing these tools and resources, checking them for compliance. You needed to set up your own IT systems in-house. Often you needed your own IT manager to manage those things. So HR and compliance was typically unaffordable for the majority of businesses in Australia. Workforce Guardian came along and we were the first company that introduced cloud-based HR solutions. So based on an annual subscription-based service, everything was available online, you had access to experts, and over that time we've then built a whole series of partnerships with people in this area, but through this annual subscription you get everything you need. We do all the hard work, you log in, it's all available. Over the last 10 years, we've built up thousands of relationships, we've helped thousands of employers, even thousands more of key advisors, such as HR managers, payroll people, directors of companies. So in that 10 years, we've got a really good understanding of what really happens in Australian businesses. We've also partnered with over 300 people. People like Telstra, if you go and have a look at the Telstra HR system that's available on their marketplace, that's us, it's white labelled as them, but we provide the service behind. A lot of these other industry associations, franchise groups, rely on us and provide white label services to their customers that are ours. So during that whole period and through that experience, that's what's helped us understand these things, and hopefully in the next sort of 25 minutes to half an hour, I can break it down into some really practical information and then show you a few quick things you can do to comply and keep your costs down. So quickly I'm going to talk about why is HR important in Australia. So 3 key things that really matter to every business, no matter whether you have 0 staff and you only have contractors or whether you have 10,000 staff. Second of all, I'm going to talk about what these top 10 HR mistakes are that people are making, and then finally show you a few quick things that you can do to avoid them. Does that sound relevant to everybody here? Okay, so I can make this information as tailored as possible, can I just see a quick show of hands? Who here owns a business? Okay, can you keep your hand up or raise your hand if you employ employees or contractors? Okay, does anybody here look after payroll for a business? Okay, is anybody the director of a company that is ultimately responsible for somebody else doing the payroll? Cool. So we have some key advisors here as well. Okay, anybody here an employee or a contractor of a company? Okay, so you want to make sure you get paid properly. Excellent. Just helps me shape the information as I go through and make it relevant. So why is HR important in Australia? The number one reason is that the majority of your workforce costs relate to your people. If you have good HR, typically you're going to have a good business. You have bad HR, typically you're going to have a bad business. You look after your people are going to look after you. If you don't look after your people, those people are going to cost you a lot of money in lost productivity, potential employee claims, etc., etc. Okay, so this is always the reason. No matter what else we talk about, it always comes down to the cost in your business, because at the end you want to run a profitable business. Bad HR is going to cost you money and potentially run your losses. Number 2, like it or not, Australia has some of the most complex employment relation laws in the world. And it doesn't matter if you have 0 employees or if you have 10,000 employees, you need to comply with the same legislation. Has everybody here heard of the Fair Work Act? Okay, good stuff. What's your level of understanding of it? Do you like it? Okay, it's quite challenging. Over 10,000 pages of legislation, over 10,000 wage combinations, 122 modern awards you need to work out. Applies to the majority of businesses in Australia, including small business. There's also some provisions that impact on contractors as well. But ultimately, unless you're in various parts of WA or you're working for the government, the majority of your employees are going to be covered by the Fair Work Act. Even if they're award-free, there are still areas of this you need to provide for all employees. There's about 400 inspectors around Australia, and their job is to travel around to audit businesses to make sure that you're compliant. And again, a lot of these inspectors, because there's a small number compared to the number of businesses in Australia, are reactive. So it's based on employees making complaints or them doing audits in a particular area where they get a particular pattern of behaviour, so they focus on those areas. So again, it takes you back to, if you have good HR and happy people, these people are not complaining to the Ombudsman. If you have unhappy people who feel like they're being disgruntled, they're more than likely making complaints, more than likely you're going to get audited. They're also starting to do a lot more remote audits via email, sending you letters where you respond to a Commonwealth documentation, and then based on that they work out if they do an audit in an area or a particular industry. And they do have media releases that they put out now all the time, warning particular industries that they're targeting them. So the risks for employers. It doesn't matter how big your business is, the potential penalties are up to $54,000 per breach. Mostly these are reserved for some of the worst cases, but if you are underpaying staff, if you're not doing some of these basics we're going to talk about, these are the potential penalties. If anybody wants to actually confirm any of this, the Fair Work Ombudsman is just over here. Go and have a chat to them. They do have some good resources. So court orders to rectify breaches, expensive employee claims, but ultimately these are the penalties you're going to face if you breach these laws. Another one that's starting to become quite important is personal fines. So people who are doing the payroll for businesses, if you're the director of a company, you are potentially liable as an accessory if your employer or if your client breaches the Fair Work Act. An example of that would be if you're doing payroll and you see a pay rate go through for a person and you look at it and you know very quickly there's no way that is above the minimum wage. If you don't check that, warn your employer to do something about it, you're potentially accepting accessory liability. And 92% of prosecutions last year included a penalty for accessory liability. Okay, so they're going after it. The third one, which is a little bit less known, how many people here have heard about general protections claims? Excellent. Okay, the big difference between is who here has heard about unfair dismissal claims? Okay, most people. A general protections claim, where it's a little bit different to, say, a unfair dismissal claim, is that an unfair dismissal claim, if I put that up against an employer, I need to prove that the employer treated me unfairly, harshly, to get rid of me. A general protections claim, I just made to make an allegation that I was adversely affected because of something the employer did to me. So it's an allegation based on one of these three attributes. So you discriminated against me when you were hiring that job because of my religion, because of my race, because I'm a man, because I'm a woman, because I'm pregnant. And the onus of proof is on the employer to show that they didn't. Okay, so the employer is effectively liable or guilty until proven innocent. Okay, very unusual for Australian-based law, but this is how the Fair Work Act works. And the damages are uncapped. That's a really important thing to point out, is that it's up to the Commission as to what damages they award. And if you want to have a look at some of the examples in the media recently, there's lots of big names being prosecuted. There's also lots of smaller businesses being prosecuted. And again, as I said, 92% of them include personal fines. So what are these top 10 HR mistakes that sort of are affecting businesses? Number one, poor hiring processes. Okay? Not having clear selection criteria. If you're hiring a job and you don't have the selection criteria actually itemised out, if it's not competency-based and you're not keeping records of what you're doing here, how can you actually show that the person you hired was the best person for the job? First of all, for your own business, are you hiring the right people or are you ending up with the wrong people, which is very costly then to get rid of them? But second of all, if they do put in a general protections claim, how can you actually show that you had good, robust hiring processes in place? How can you prove that they were the best person for the job? Second of all, no clear position descriptions. Now again, if you don't define the job duties, if you don't set out the competencies you actually expect of people, how can you blame them for not really understanding what you want of them? Then you start to get into arguments about, was it the right person for the job, the best person for the job? But then when people are in jobs and they're underperforming, everybody's happy when you're offering them a new job. You hand them the contract, I'm going to pay you an amount of money, you're all best friends. The minute something goes wrong, what do employees do? They blame you because you don't have the right systems in place, you don't have the right tools, the market's too difficult, this is wrong, that's wrong. People look for excuses. If you have clear position descriptions, it's black and white what you expect of them. They have a proactive role to tell you what they need. You then actively manage them to deliver it. It makes it very clear and you have less conflict as you go along. Number 3, how many people here are doing right to work checks? How many people know what they are? Okay, very few businesses in our experiences do these. Okay, there's this assumption that people have a right to work. First of all, you want to know, are they an Australian citizen? Do they have a visa that entitles them to do the work that you're hiring them to do? Does that visa entitle them to the number of hours that you want them to work? So these are things that are really important to check. And again, having those clear hiring processes is making sure you're doing this, because the fines and penalties are quite significant. And again, they're getting much more aggressive, I suppose, at pursuing some of these things. Number 4, poor employment contracts. Now, under law, you don't need an employment contract. The reason we would highly recommend you have one, and if you do have one, to ensure that it is compliant, is that, again, when you hire an employee, everybody's happy. Okay, people are agreeable. When there's a problem, you want to be able to fall back on something that's black and white about what your expectations were, and therefore you can have a much clearer discussion about managing performance, about managing disciplinary issues, etc., etc. One of the common things here is, and again we'll talk about the National Employment Standards a little bit further, it is referring to anything more than 38 ordinary hours in a contract. Does anybody do that in their contracts now? Okay, if you do, review them, because you can't refer to more than 38 hours. It's one of the National Employment Standards. Also, one of the other ones is including policy-based obligations as contractual terms. So if you have, say, a person who has a motor vehicle, a person who has a mobile phone, if you want to refer to that, refer to a policy in the contract. Don't include the actual terms of that inside the contract. The reason for not doing that is it then becomes a contractual term, and if there is a problem with, say, unfair dismissal or general protections, it's a breach of contract. So it's a much more serious legal obligation rather than it's just a referred term. It's less, it's implied. Number 5, and this is starting to feature in the media a lot, particularly with migrant workers, people here on holiday visas, people sort of doing picking. So particular industries there are being targeted quite heavily at the moment, but is around sham contracting. Also in the building industry, which is starting to clean up a little bit, but there's a lot of activity there at the moment. Telling somebody to go out and get an ABN and sort of, pretending that they do their own work doesn't automatically make them a contractor. There's legislation around who they are, and just be mindful if you are calling them a contractor and they're not. Again, the Commission has the power to have court orders around what they do with these people. And also contractors have obligations under these general protections. They can still say they were unfairly treated or discriminated as well. So it's very important to make sure if you're employing people, if they're employees, classify them as employees and treat them as such. So again, the risks, big penalties, court orders and general protections do cover contractors, some of the provisions there. Again, lots of prosecutions for people in this space if you want to go and Google and have a look at some of the examples. Number 6, poor managing processes. Not providing up-to-date HR policies. Again, if you don't have things in writing, there's this sort of assumption that people know what you expect of them. Having clear HR policies in place makes it black and white. It is much clearer when a person then doesn't deliver them to go and have a discussion with them about why not. Much easier to deal with performance management issues, and in today's day and age when you deal with people, there's always going to be issues around performance. And no matter how well people perform as a business owner, your challenge is to get them to perform better. Okay, even your high performers, you want them to perform better. People are constantly improving. More productivity, more performance. That's how your business grows. But also keeping people happy. And happy people are people who understand their expectations. There's no uncertainty. Uncertainty is what bothers people, and then they become, a bit more aggressive. Then you start to have a lot of the issues that relate from that. Bullying. Bullying and harassment is also a big area of focus at the moment, where again, employees can make complaints where they feel like they're being bullied in the workplace, and under the legislation, you need to have investigative processes in place where you respond to that and make sure these people are not in positions of risk. Because again, if they feel like they're bullied, you don't respond, all of a sudden they're off on sick or personal leave. They're then making, allegations that you as an employer made them unwell. Then you end up potentially with work cover claims, huge expense. So the best thing is if a person feels like they're bullied, you want to respond quickly and manage these issues. Employment handbooks are a really good way to get this started, particularly if you're a small business. You don't want to invest a huge amount of time in this sort of thing, but you do want to sort of get a basic manual together with your policies, explain what you expect of your employees, and get the conversation started. Then you can keep it up to date, get some feedback from your employees, whether they agree with you, disagree with you, but everyone shapes the business going forward. They're all a part of the same shared success. Number 7, national employment standards. And the next few that I'm going to cover off are incredibly important because of your compliance obligations. Is everybody here issuing the Fair Work information statements to their employees? Has anybody not heard of the Fair Work information statements? Okay, if you haven't, one of the first things that the Fair Work Ombudsman or Fair Work inspectors generally will check is that you have issued your Fair Work information statements to your employees. If you don't have a copy, you can Google it or you can get it off the Fair Work Ombudsman's website or you can contact us, but that's the first thing you should give them. The reason for that is that you're then making employees aware of what their legal obligations are, what their rights are. It also then makes it easier for you to understand what you should be providing them. If you don't provide this, it's a $540 fine per person, and that's where the Fair Work inspector will generally start. Then they'll move on to your pay slips. Again, the 38 hours. And also cashing out employees' leave if they're still a person. There are some changes in this area at the moment if they're over 8 weeks of entitlement, but check the current model award as to whether it is lawful in that circumstance. It depends on the award. So these are the 10 national employment standards if you haven't seen them. Number 10 there is the Fair Work information statement. Number 1 is the maximum weekly hours that we just talked about, around the 38 hours. And by that, the terminology you should be using is 38 hours, like ordinary hours, plus reasonable overtime. Reasonable then depends on the industry they're in, the type of job they have, and a negotiation you have with the employee in your workplace. But again, 1 and 10, incredibly important. There's some others in there as well around public holidays, flexible working arrangements that people have rights to now. So you can read a little bit more about these or contact us if you want to know a little bit more about them. But the 2 key ones are those ordinary hours and the Fair Work information statement, which will start to explain these. Number 8 is underpaying workers. Now, the majority of people who are actually caught underpaying workers, apart from some of the really bad serial pests in this country who do it deliberately, is that they generally try to do the right thing. The reason they get it wrong is they often don't understand the modern award system that is part of the Fair Work Act. Under the Fair Work Act, there's just over 122 modern awards that cover most employees in Australia. Now, depending on that award and which employee is covered by that award, it will determine the minimum rate of pay, the allowances, the loadings, all the other things that those employees are entitled to. So you need to make sure you've done your modern award classifications. If you're unsure, there are tools that are available through the Fair Work Ombudsman website, or there's services such as ours that can help you to do that. If you're a key advisor, so say a payroll person doing this for employees, I highly recommend getting this in writing when you get these classifications, because then you can use that to protect yourself. If you're making the determination and passing that on to a third person, again, you're exposing yourself to accessory liability. So make sure you're comfortable with what you're doing. So again, modern awards, not paying the right loadings. So modern awards apply as a matter of law. It's not a choice whether you apply them or not. They must be applied. So the first thing you want to determine is, are you covered by the Fair Work Act? Are these employees award covered or award free? Do you have enterprise agreements in place, which most small to medium businesses don't, But if you're doing payroll for a larger business, just check if there is an enterprise agreement in place. And they set out all these compulsory terms. And again, $54,000 breach for each of these things you're getting wrong. And potentially that can be applied per person, per pay period, up to 7 years. So the fines can be huge. A recent example is 7-Eleven. One of the main reasons for 7-Eleven's penalties at the moment is that they classified their employees under the wrong award, and they also then falsified timesheets, and a few recent colourful things they've done since. But they're up to about $114 million, and this is all tracked online as part of their compliance obligations now, but their back pay has just exceeded $114 million. So that's what happens when you get it wrong. This case in particular has also escalated this to the federal government level, where they're now considering increasing penalties from $54,000 to $540,000. Okay, massive increase in penalties. So without any surprise, franchises are now a key target group for the Fair Work Ombudsman. So if you're involved in a franchise group, they'll be coming after you shortly. And have a look at the cases for Domino's, Pizza Hut, and a whole series of others that are being impacted at the moment. Record keeping and pay slips, again, very important. Often the second thing that a Fair Work inspector will check, they're going to be seeing whether you've issued your Fair Work information statement. The second thing they want to know is, are you giving a pay slip within 1 working day of payday, even if your employee is on leave? Okay, so it needs to be emailed through, post and arrive, whatever the agreement is you have with your employee, but it needs to be within 1 working day. It needs to have a whole series of compulsory information on that pay slip. And if you need more information about that, contact us. And again, not keeping time and wages records. Some of the modern awards require you to keep time and wages records for each of those employees to determine how have you calculated the amount of money you're paying them. So again, think back to the 7-Eleven example. Okay, one of the reasons why they underpaid people is they had them working 60, 80, 100 hours, but then on the pay slip, it was down for 38 hours. So it sort of seemed to be the right pay, but they were actually falsifying those records. And this is a big area of focus. The Fair Work Ombudsman actually has an app they've recently released, which helps you to track these time. And probably more concerning for employers is that it actually is available for employees. So employees can start to track this information. So if you are breaching the law, it can be used against you as part of those prosecutions. There's also an anonymous tip-off service, which I think has just reached 10,000 tip-offs. So family and friends of employees, so particularly young workers, can dob you in if they think you're breaching the law. So suddenly then out comes the inspector, looks over your stuff. So if you're not doing the right thing, there's more chance of you being caught. So as we just covered off here, first documents they often check. Number 10 is your poor exiting processes. Now this is ultimately where a lot of businesses get impacted and it costs them a lot of money. I mean, a lot of the questions we get through the advice service through our services is around unfair dismissals and general protections claims, people that were terminated harshly and unfairly. And one of the big things that distinguishes often between whether it's harsh and unreasonable is not what you would consider reasonable. Okay, employee turning up at work, punching you in the face. An employee turning up drunk. Okay, these are things that I think a common person would deem reasonable. Okay, I'm under threat, I would deem them. But often there are a lot of cases whereby if you haven't actually given a person the opportunity to show cause why they should not be terminated, they will often be ruled unreasonable. It was harsh. A person stole money out of the cash register. I consider that serious misconduct. I terminate them. If I didn't actually ask them to show cause why they should not be terminated, my family was starving. My grandmother is terminally ill. I needed that money to save her life. There are some of these cases where people have been reinstated or they've got payouts and have been awarded damages because the Commission did not deem it reasonable. So no matter why you are terminating people, I highly recommend ask them to show cause why they shouldn't be. Why you're defending yourself from the second punch. Okay, but very important to avoid unfair dismissals and general protections claims. And then the final one is if you're doing redundancies, don't re-advertise the same job exactly the same way it is a week later, because surprise, surprise, it won't be shown up as being a genuine redundancy. Change the title, change the duties, make it look like it is a totally different job. Because if the same person can fit that same job that you're re-advertising, it's not a genuine redundancy. And the number of unfair dismissals has tripled So again, this is becoming more and more of an issue for employers, and it doesn't matter if you're a small employer or a big employer, it's equally a problem. So the bottom line is HR mistakes can be costly. Okay, so that's the sort of the scare, that's the risks of what's going to happen to your business. And if you've got any issues in that sort of area, the main thing is now, what can you actually do to avoid them? Number one, you want to make sure you've got compliant HR processes in place. Now, you can either go and engage a HR professional, an employment lawyer. I mean, there's a whole series of services out there similar to ours. There's industry associations, or there's companies like Workforce Guardian. We offer subscription-based services that have all of these processes in there as flowcharts. Each of the steps lines up with the document you need. But ultimately, there's a whole range of services out there to help you get these in place. Just make sure they're compliant. Ensure you have the correct award coverage. If you have employees that are covered by the Fair Work Act, which is the majority of employees, make sure you're doing a modern award classification, and make sure it's in writing if you're a key advisor, so it protects you. The Fair Work Ombudsman has a great tool called PACT. If you find that a little bit complicated, again, services like Workforce Guardian provide that service, and we do the classification for you. We provide that advice in writing. We also do the pay grade within the award. But again, you have some choices. Number three, make sure your tools are all compliant and make sure they're kept up to date. So they're set for Australian employment laws, not for international laws, because overseas is very different to Australia. So things like your policies, things like your employment contracts, again, your employment handbook is a great place to start. Get advice if you need it. If all these questions are keeping you up at night, there's plenty of experts out there that can help you. Just make sure you go to an employment lawyer, not a general lawyer, or a service like Workforce Guardian. So people who specialise in answering these questions all day long. And also you can get different advice depending on what's the law and also what happens in practice. And finally, make sure you're keeping your HR records for 7 years. And make sure you're keeping them in a format that is legible, is protecting you from any privacy breaches, but they're accessible if a Fair Work inspector comes in, or potentially if an employee requests a copy of their personnel file. But again, that it backs you up. If you have any general protections claims, any issues with employees, these records are there to protect you and hopefully stop some of these other more serious issues escalating. So finally, that's our contact details if you do need any help. If you would like a free HR health check, which breaks this down to some questions you can ask yourself and allow you to prioritise different areas, please come and just give me your contact details. I can email that through. And if you have any feedback about this presentation, more information you would like, please just send me through an email and I'd be happy to help. Does anybody have any questions while I'm here? I have a bit of time. Very thorough. Afraid to ask. Cheers. Thank you very much for your time.